The first one is what happens when I become incapacitated.
You're muted.
Can you hear me now?
Yes.
Okay, I'm sorry about that.
So I can,
Yeah.
we can hear you, but we're also getting an echo. So if everyone else would go on mute, that would help.
Is it better now? I assume with no answers, that means it's better. Yeah, estate planning. There's kind of four major categories for estate planning. And the first is planning for incapacity. And, some of us may be getting there or close to getting there. Some of us may not ever get there, but it's very important to plan for incapacity. And then after incapacity, the next level of planning deals with terminal illness. And so some of us may experience that, some of us may not. And then the third category, of which sadly we'll all experience, is death. And so planning for incapacity, terminal illness, and then planning for death. And then finally, planning for what happens to your stuff. The first three categories deal with you personally. And then finally, upon death, there is the question of what do we do with your assets? And so the next slide is incapacity, and then go on to the next slide. And there's two very important documents. Probably most people think about wills and trust, but these, in my opinion, are the two most important documents for you to have because they deal with you. They deal with you while you're living, but yet unable to make your own decisions. So probably the two most important documents for you to consider is a durable general power of attorney and a durable power of attorney for healthcare. And so the next slide, durable general power of attorney. Next slide. Durable means it survives your incapacity. And so what a durable general power of attorney does, it authorizes someone to make your decisions when you're either unable to do so or cannot do so. And there's two versions of a durable general power of attorney. One is what I call a current power of attorney, meaning when I sign that document on November the 10th, 2020, it becomes effective that day. And so whoever I appoint as my agent can then utilize it on my behalf without any further requirements. A springing power of attorney is one that comes into effect upon some later event. And generally it would be when I'm declared incapacitated. And yes, ma'am. The difference is on a springing power of attorney, someone has to prove I'm incapacitated. So, and that would be a medical professional that does that. Whereas with a current one, you don't have to go through that proof. And some people, if you're choosing an agent or whoever's going to represent you, if you really trust them, then you probably prefer to do a current one. That way there's no need for someone to declare you incapacitated. Whereas with a springing power of attorney, you would have to go through the process of being declared incapacitated. And, that's some people don't like that. And I cannot fully understand why you would not want to go through that process. So there's two different versions with regard to a general durable power of attorney. And typically these are documents that have formalities and they are to be acknowledged, which typically means a notary has to approve your signature. So next slide. A general durable power of attorney basically applies to your financial assets. So typically it will apply to your checking accounts and your other accounts that are listed in assets in your name. In addition, you typically find these powers kind of go beyond just paying my bills and depositing my checks when I can't do so. And a problem a lot of people have are people who have safe deposit boxes. There's fewer and fewer of those nowadays, but 20, 30, 40 years ago, most people had them. And banks are very picky about who gets to get in them. So if you have one, by all means, make sure you have someone else who's able to get into it when you can't, because otherwise it's an ordeal. You have to crack the safe, so to speak, to get in them. So a lot of times if you have a safe deposit box, you want your power of attorney to have access to it. So you would need to specifically say it in the document. That's not implied. Likewise, it's probably prudent in this document to say my power of attorney can prepare a trust or revoke a trust or amend a trust that's part of my estate planning. Because these things will be working simultaneously. So oftentimes if you have a revocable trust, you probably want to give your power of attorney certain powers, especially to create one. Once you become incapacitated, moving things to a trust is going to be easier to manage than things being in your individual name. More aggressive powers, which most people don't want to give their power of attorney, is the ability to alter beneficiary designations. That would be changing who gets your retirement account, changing who gets your life insurance. You probably need to have a ton of confidence in who you're naming as your agent to give them this power. If you're nervous about it, I would not give them the power to change a beneficiary designation. But these things would specifically need to be added. The generic one would say you can just take care of my financial affairs, and generally speaking, doing aggressive things such as creating a trust or changing beneficiary designations will not be implied unless you specifically state it. And the same with gifts. Once you become incapacitated, your agent or your attorney, in fact, can only do things for your benefit. And one would say making gifts to family or to charities is not beneficial to you. And that's kind of implied, even though you may have had a pattern of giving a check every week to your church or giving your kids and grandkids and in-laws gifts at various times. Your attorney, in fact, probably doesn't have the power to do so unless you specifically say it. So it's important to consider who can make gifts and to whom and how much in the event you cannot. And so it's probably wise to add a power for your agent to make these gifts if that's what you want. Next slide. Powers of attorney are ways to avoid a guardianship and avoid a conservatorship. Those are court orders. So if you become incapacitated and you don't have a power of attorney, then somebody's going to have to go to court and get a guardian or a conservator appointed on your behalf. It's administratively, there's a lot of effort there. You got to get the medical professionals involved to declare you incompetent. Then you have to, or not declare you, but provide information for the judge to declare you incompetent. And then you'd have to go to a hearing and have people present evidence as to your incompetency, and then also have to present evidence as to who is the best person to be your guardian or your conservator. But this is that kind of, once you rely on that, it's out of your hands because you're incompetent, assuming that's the right conclusion. And so it's really family members fighting over who's in charge, if that's a scenario. So it's best to have a power of attorney because you can say, I want this person to be in charge if I can't, and avoid all this. But there could be a need to have a conservator or a guardian if things kind of get messy. But yet power of attorney is hopefully avoids the need for this, but if needed, they work together, and then eventually the guardian or the conservator actually takes control over the power of attorney. Next slide. The multiple. So a lot of times the typical plan, most people say, is, okay, I want my spouse to be if I become incapacitated, I want my spouse to make all my financial decisions. And if my spouse can't, then I want all my children to do it. And so if you name multiple people, then you need to be clear on, should it be a unanimous decision? Should it be a majority decision? Or can either one of them act independent of each other? So just a clarification, if you choose multiple people, how do they operate as a group? And it can be any of those three. Our legislators have provided a form. So if you don't want to have to call an attorney up, you can get a form. There's a statutory form, power of attorney, in our statutes. You can probably Google or go online and find one. So they're readily available, but yet you need to be careful that there are certain things that you may want to add to it. The things we previously discussed, such as making sure they can make gifts, and just make sure it fits what you need. Next slide. You can always revoke it, assuming you have the capacity. So if I sign one today, I could sign another one tomorrow and another one the next day. And so I can always revoke it. I can always do new ones. It's very similar to a will. But here, death terminates the power. And that's always a confusing thing to families is a parent dies and the child says, well, I've got the power of attorney, so I'm going to go down to the bank and clean out all the accounts. Or not clean out to take, but to administratively get things right. Well, powers of attorney cease to be effective upon death. So it's only good while the principal, which is you, is alive. But the funny thing about powers of attorney is they don't necessarily revoke your prior one. So if I sign one today, and then sign one tomorrow, but the one I signed tomorrow doesn't revoke the one I signed today, you have multiple powers of attorney. So things can get confusing. So if you're redoing one or wanting to make sure a prior one is not applicable, you got to make sure in the newer one you say, I hereby revoke all prior powers of attorney. And it's important to go and round up all of the powers of attorney you've ever given anyone. And sometimes banks will say, I want a copy of it, or your broker or other people. So if you ever change one, it's important to remember who all had the old version, because they won't know about the new version. So be very reluctant to give someone a copy of your power of attorney. And if so, make a note of it so that you can recall it if you ever change it. Next slide. Powers of attorney don't overrule everything. They're only applicable to things that you own in your name. So if it's something in a trust, power of attorney has no application to it. The trust document controls that. If it's joint ownership, power of attorney only applies to your sliver of that joint ownership. If it's half, then it only applies to half. If it's a third, it only applies to a third. So it's only applicable to those things that you own in your individual name. If you're a partner in a partnership, or you've got an LLC or other business arrangements, oftentimes buried in those documents, it will say if a partner ever becomes incapacitated, then they don't get a vote. And so your power of attorney may not necessarily allow you to step into a partnership or an LLC if you become incapacitated. because oftentimes those agreements will just say you become a passive partner and not a voting partner. And then retirement plans, sometimes they will build in or ask you who can, who can I give information to, who can provide, transactional recommendations and whatnot. So sometimes in your retirement plans, you may name somebody to have authorization to information and decision making that again would supersede this document I'm talking about. But in the case of if it doesn't have you designate somebody, then your normal power of attorney will apply. Next slide. Then we move into that power of attorney dealt with your financial affairs. Then a separate, but it could all be part of one document, a separate power of attorney will deal with your healthcare decisions. Next slide. And healthcare is kind of all inclusive, all care, treatment, and procedures, but yet it will not apply to life sustaining treatment. There's another document that we'll talk later, living will or declaration, that will apply to situations when you're terminally ill. But a healthcare power of attorney will generally apply to your normal everyday healthcare decisions. Next slide. And there's a little more formalities. Anytime you start talking about health related agencies and authorities, there's a little more formalities. Typically it has to be witnessed by 2 witnesses, but just recently our state said it can either be 2 witnesses or acknowledged by a notary. So there's no longer the requirement for 2 witnesses, but there's a formality to this document. Writing, signed, and either witness or acknowledged by a notary. Next page. Whoever, and again, this is an important document for you because you get to hand pick who is going to make your healthcare decisions. You're not relying on the state of Arkansas statutes or someone going to court and being named your guardian. You get to declare, I want this person to make my healthcare decisions. And so you avoid any controversy as to who should be your representative. And again, the typical plan most people do is they'll say spouse first, kids second. And so the same thing would apply if you name multiple people, should they act by majority rule, unanimous rule, or individually. Typically, at the same time we have people sign a healthcare power of attorney, we will have them sign a HIPAA authorization that would say whoever that person is will have all the ability to access the person's medical records. Next page. Again, these are documents that can be revoked and redone at any time, assuming you have the capacity. And so, again, a newer healthcare power of attorney does not necessarily revoke a prior one unless you so state. And so powers of attorneys are funny in that it's not the last one you signed, unless the last one you signed revoked all prior documents. So it's important if you ever do a new one, make sure you revoke all prior healthcare powers of attorney. And the same thing would apply if you've given one to your doctor or you've given one to a clinic and you redo one, make sure you go and swap them out just so everybody has the latest and the greatest version of this document. Next page. And then you move into the healthcare power of attorney addresses everything but your terminally ill situations, your withholding or of life support type decisions. And so if you go to the next slide, when you become terminally ill, there are typically 3 documents or declarations that become applicable to how to handle your health in that situation. And the most common thing is a living will. Here in Arkansas, we call it a declaration to physicians, but it's the so-called pulling of the plug document. And then A statutory document is a proxy, and that typically applies when you don't have any guidance as to who's going to make your healthcare decision. And then some people like a do not resuscitate declaration, either in their records or on their body in some form or fashion. So next slide. Go to the next slide. Thank you. The one I primarily deal with is a declaration to physicians or living will. And it's really your declaration as to what level to withhold or withdraw any life-sustaining treatment. And again, a lot of formalities to this. Has to be in writing, signed. Historically, it had to be witnessed by 2 people. Now we can just simply acknowledge it. But it only becomes effective when there's a terminal condition or permanently unconscious. And this is a decision that's medically driven by your attending physician and another physician. Luckily for a lot of us married people, it's not driven by your spouse, so they can't declare that you're terminally ill. It's a medical determination. And if you give it to your care provider, then there's formalities there at the hospital or the clinic that they make sure it's part of your record, so that everybody attending, all the physicians attending to you, will know your position on what level of life-sustaining treatment that you want. Arkansas, in addition to this written document that would say, either I want life-sustaining treatment or I don't, or to what level you want, you can always add clear and convincing evidence of additional information. So obviously, if the patient can speak and is aware of certain things, then that can override or be additional information in addition to what's written in the document. Next page. Again, with all these documents, they can be revoked. And there's a little more aggressive ability to revoke a living will, in that our statutes say at any time and in any manner, without regard to the patient's physical or mental condition. So if someone is on their deathbed and says, I'll revoke my living will, then legally they have revoked their living will. And so there's the ability to always undo any living will that would say, I don't want heroic efforts in supporting my life. The patient can always revoke that. Here's where it gets, everyone has their own little spin on this. In my world, to what level do you want nutrition and hydration? And people have different approaches to that. Our statute allows you to pick how much or how little you want. You're always going to be giving comfort, care, and alleviation of pain. So in any scenario, if you choose no life-sustaining effort or the maximum life-sustaining effort, you'll always be provided for comfort, care, and alleviation of pain. The question for most of my clients is the feeding tube. Do you or do you not want that? And so people will debate to what extent they want nutrition and hydration. And if you need to be clear as to your position on that in this document. Next slide. Proxy, next slide. Proxy is more of a statutory, I don't do those, planners don't do those. These are things either hospitals or clinics or other entities provide. It really comes down to people who don't have documents, who haven't done a durable power of attorney for healthcare, haven't done a living will. And so there's a form the state of Arkansas has created and made it available to where people can name a proxy. And that's just simply naming someone to make my decisions when I can't. And if a patient comes in that has no family, no identification of who would make that decision, then the provider can name a surrogate to make those decisions. So it's just another mechanism to cover people who don't come in with powers of attorney and living wills. Next page. If you don't name somebody, and that's kind of really the important reason why you should do powers of attorney for financial and powers of attorney for healthcare and living wills, is because you get to name who your decision makers are. And you can have a first choice, a second choice, a third choice. You can have a team of people. And so that gives you the ability to handpick who you want to make decisions when you can't. In the event you don't do so, then it will be a guardian. And again, a guardian is a court-appointed person after a hearing to declare you're incompetent, and then a hearing, also the same hearing, to determine who is best to serve as your guardian. And again, you've lost control there. You've lost control over being able to handpick who your representative will be when you can't. If there's no legal guardian, then for a minor, it would obviously be the parents. For a married person, it would be the spouse. And then you just go through the process of spouse, children, parents, siblings. And so the statute will always find somebody, assuming you have a close relative. Next page. Do not resuscitate is something that's provided. I don't do those. Those are provided by the medical professionals. And flip to the next page. And it's some approved, I've seen people wearing bracelets or necklaces, or it's either in their governing documents, their medical documents, that they want to make that declaration. But that is something done with the hospitals and the medical providers, and not done with the planners. So next slide. And then next slide. As we all were getting excited, now we lead up to death. We've talked about you losing your mind and going crazy and not being able to make your own decisions. And now we finally get to the happy ending of the story of death. I live a weird life in that when I meet with clients, it's not, how's the weather or who won the game. It's okay, what do we do now once you've died? So it's not the most exciting topic to talk about. But I think it's Ben Franklin, as he said, isn't death and taxes the only two things we can count on? So death is always going to be on the horizon for all of us. Next slide. There are kind of three personal documents to consider with regard to death, and some of them you can have a document that says where you stand on autopsies, where you stand on anatomical gifts, and then the final disposition of your body. And so next slide, with an autopsy, next slide. It's a written declaration. Some people want to have an autopsy. Some people want to avoid an autopsy. Most people don't care. But if you have a preference, you can always do a written statement as to your preference. Otherwise, it will be your family that will either approve or disapprove of an autopsy. Next slide. More common are people wanting to make anatomical gifts. Next slide. And it's our state has gone out of its way to make it easy for people to make anatomical gifts. You can any adult or anybody getting a driver's license, for that matter, can do it. If you fail to do it, then your healthcare agent under your healthcare power of attorney could do it, or if you have a guardian, your guardian can always make anatomical gifts. Next page. And again, you can do it on driver's license. You can do it in your will. If you're on your deathbed, you can do it by just some oral statement. And then there's the donor registries and donor cards that you can do. Next page. Alternatively, if you're against it, you can always do a refusal to make a gift in kind of the same fashion, some kind of signed record or some kind of signed declaration. Next page. And then your final disposition, what to do with your body. Next page. If you have a plan, probably the most common thing I see is people want to be cremated. You would want to incorporate that into your documents by making a statement as to what the plan is for your body to either be cremated or buried or whatever process you want. If you have a plan, then it's good to put that in your healthcare document. And again, there's formalities here that has to be signed and 2 witnesses, and those type of things. Next page. So finally, we get to kind of asset disposition. This is, you've died, then what happens to your assets? And if you go to the next slide, there are typically 4 kind of governing documents that will be applicable, and they're in the order of superseding the other. Title always controls. Something jointly owned with your spouse will always get it, 100% of it. If something are jointly owned with a child and you have a designation with right of survivorship, on your death, child will get 100% of it. So title is very critical in determining who gets what, because that's the top shelf. That's the first thing we ask is, okay, we need to see how things were titled when someone has died, because that will determine whether or not someone automatically gets it, or we have to dig a little further. Second is designations. These are things typically on life insurance or retirement accounts, and that will control, again, over your will and over your trust. So it's very, very important to keep track of your beneficiary designations. Thirdly, a trust. If something's owned by a trust, then the trust controls that disposition. And then kind of the default is a will. A will will finally control anything that's not controlled by any of those 3. If it's not controlled by title, designation, or trust, then your will becomes the controlling document. And for those who have nothing, no will, no trust, no designation, no title, then Arkansas statute provides a default. And then also there's always a chance for taxes upon death. So next slide. Title. Next slide. Title, again, is the most superior way to receive an inheritance. Joint property with survivorship always passes to the survivor. So most people's homes are owned as husband and wife. First one to die, home automatically goes to the survivor, 100% of the home. Even though your will could say something else, or your trust could say something else, irrelevant. Title supersedes everything. In addition, putting someone's name on an account is not a good thing to do. And a lot of times I'll have people come in and say, well, I'm going to put one of my kids' name on all these accounts, just so in case something happens to me, they'll be able to access it. Generally, that's not a good idea, because the child whose name is on that account, one, could rob you. And then 2, if that child ever got in trouble, had a car wreck, got divorced, someone could lay claim to that account solely based on the fact that the child's name is on the account. So it's best not to put ownership onto with a child. There's always a better way to do it. You can through powers of attorney or through some kind of payable on death. But a lot of problems pop up when you put one child's name on an account. Another problem is that, say you have 3 kids and you put one of them on every account. Well, that one child gets it all and doesn't necessarily have to share it with the other 2 children. And so it just creates a lot of problems and a mess putting someone's name on your account. There's always going to be a better way to do it. Next slide. Designations. Next slide. So if something is not jointly owned with right of survivorship, then the next question is there any kind of designation on this account? And again, your will not control life insurance or retirement accounts that have designations. And the nice thing about designations is they're not subject to probate. So typically life insurance will go, as you fill out that form, and your retirement accounts will go as you fill out that form. And there's no need for probate, and your will cannot override that. So it's important to make sure if you want to change your retirement and life insurance designations, that you have an inventory of your life insurance and retirement accounts. And that sounds easy, but people have a hard time keeping up with their affairs as they get older. So it's important to make sure you leave a paper trail, because someone may have to step into your shoes and figure out where all you have accounts and life insurance and that type of thing. But those designations control. Probably the best story, the worst story I have on that is even if you get divorced, if your life insurance still has the name of your ex-spouse will get it. So it's important for if you've been through a divorce, to go back in and clean up anything that may have had each other's name on it, because divorce does not automatically revoke a designation on a life insurance. Retirement accounts, some of them it will, some of them it won't. So it's important, again, to redo everything in the event of divorce. With investment accounts, bank accounts, savings accounts, you can typically do a payable or transfer on death designation. Again, anytime you open an account or have an account, you probably want to consider making some kind of designation as to what happens on your death with regard to those accounts, and then also remembering what you've done, so in case you ever want to change it. Real estate, you can, in Arkansas, not all states, but in Arkansas, you can do a beneficiary deed. That's a deed you sign today, you file today, and you say, when I die, or when my wife and I die, this piece of property goes to my kids or this trust or wherever you want it to go. And you file that deed. And so that's another way of moving property automatically on death. Really, all you need is a death certificate. You don't have to go to probate. You don't need any administration. Those things with designation just automatically happen. So it's a really easy way to transfer assets without the need of law. I'm cutting back on my own work. Lawyers or accountants are having to go to court. Very important to make sure you utilize as many of these designations as you can, because it's a so much easier way to transfer assets upon a death. Next slide. A trust. Next slide. A trust is probably it's clearly a more formal document. Many times it's viewed as a will replacement, and trusts are very popular as people get older and people acquire more assets and different types of assets. At some point, most people will need a trust if they want to achieve a very easily administrative estate. A trust is kind of in its world of its own. It's not subject to your will. It's not subject to probate. It's not subject to your powers of attorney or a guardian. A trust is a separate entity, and the terms of the trust will apply, and not your will, not what the probate court says, or not what your power of attorney says. You just look at the document. And so a trust is kind of a separate entity that has its own rules. And so if you do a trust, you can fund it now, or you can fund it through beneficiary designations, such as life insurance or retirement accounts. You could say, pay to my trust. And likewise, other accounts can all be linked to it. And that's typically what you do if you do what we call a revocable trust. If you go to the next slide, a revocable trust is the will substitute. And people like a revocable trust because it avoids probate, and it's private. And for those who have tax issues, it gives you some tax advantages. But the point to a revocable trust is that you want it to become the owner of all of your assets, either while you're living, or you want all your assets to funnel to this trust through designations upon death. And so A lot of times people do a revocable trust and they'll forget to fund it or forget to link all their assets to it, and then you're stuck back in probate. So it's critical if you do a revocable trust that you link everything to it, and that would be assigning ownership of your investment accounts and your land and your partnership interests while you're living. You want to retitle all that in the name of your trust. And then things that only are applicable upon death, such as life insurance and retirement accounts, you would then want to probably in all likelihood designate your trust as the recipient of it. The nice thing about using a revocable trust, you get probate avoidance, it's private, wills you file at the courthouse and anyone can see what your will says. Trust or private, but yet it's an easy way to keep track of things. People lose track of, do I have this kid's name on this CD or my grandkids on this account? And if you just say, have everything roll into your revocable trust on your death, either because you own it there right now or it funnels there, and then your revocable trust is really the only document you care about it. Then it will say, give each grandkid $10,000. Give my kids this, give whatever. So you have one document that has your plan. If you start relying on beneficiary designations, something could get sideways, especially if a child were to predecease you, there's just things that can go wrong because you're having to keep up with multiple designations. So whereas with a revocable trust, people like it because you just funnel everything to this one document, and then that one document will have your plan. Here's what happens when I die if my spouse survives me. Here's what happens if I die if my spouse doesn't survive me. But as long as you funnel everything to it, then everything goes as planned. A trust offers some estate and income tax benefits that just using a will or designations don't give you the same achievement. With married couples, a joint trust is a very powerful document, especially for people who are in second marriages, because oftentimes the fear of those in second marriages is, if I die first, is my spouse going to favor the spouse's family and cut my family out? And that's a common concern, and it happens a lot. But the married couple can create a joint trust that says, okay, we're going to put all of our assets in this joint trust that husband and wife create. But yet, when the first one dies, it becomes irrevocable. No one can change anything. And whatever the plan is at that point in time is the plan forever. So the survivor can't change it. And the survivor can't control, let's just say it's a 50-50 split between husband's kids and wife's kids on the second death. No one can change that. So a lot of second married couples like the idea of doing this joint trust that provides a plan for the married couple, and just because someone survives the other, they can't change it. And if the survivor remarries, the trust says no new spouse, no stepkids can ever get into the mix. It's just the husband and the wife and the two kids that exist at the time of the first death. And so a lot of times with second marriage, joint trust becomes the preferred tool to prevent any kind of issue on the survivor kind of getting the ability to do whatever he or she wants to, because a lot of times assets owned jointly, the survivor automatically has total ownership and can do whatever the survivor wants. So joint trust is very powerful in that regard. And you also get some asset protection. That means creditors and divorces and whatnot, new marriages, by utilizing a trust and keeping assets in a trust. You get to control who benefits from it, and no one else in the world can add themselves as a beneficiary. It's only those that you have identified in the trust document. Next slide. Another type of trust, and it's not as common, is an irrevocable trust. The revocable trust that we just talked about is the more common one. Some people call it a living trust, but it's one of these trusts. It's really just a will substitute. An irrevocable trust is something you create while you're living, and you can't undo it. And there's got to be a reason why you're creating an irrevocable trust. It's not like a revocable trust, which is very common. You got to have a particular reason, and one reason may be asset protection. You know, people, especially people who go out and develop land or do a lot of doctors are worried about being sued. You know, I've worked all my life, saved all this up, and then the last deal I do goes bad, and then I lose everything. And so commonly people can take their wealth that they've earned now and put it in an irrevocable trust now, and those assets cannot be touched by anybody. And so if I get sued, or if I go bankrupt, but I've previously moved assets into an irrevocable trust, no one can touch it but whoever I say so. And so it'd be my wife and my kids. And so if bad things then happen to me afterwards, those assets are protected from creditors and lawsuits and whatnot. Another reason for those with large estates, irrevocable trust is a tool that we encourage people to make gifts and transfers to while they're living, so that they can remove assets from their estate and the appreciation on those assets from their estate. So there's a transfer tax, estate tax reason why people would fund and set up an irrevocable trust. The nice thing about a trust is it's your terms. You get to say what your beneficiaries get, when they get it, how much they get. So it's a way of controlling from the grave. A lot of people like that. And so you get to set it up as you desire. And as I said, they're asset protected trust. And another phrase people use is a spendthrift trust. That means creditors or spouses or former spouses can't access a irrevocable trust. And so it's only your listed beneficiaries, which typically is your spouse and kids and grandkids and so on, are the only beneficiaries, and no one else can. Commonly, irrevocable trust is used for life insurance. If people go out and buy a big life insurance policy, and they have minor kids in particular, you got to use a trust because minors can't inherit anything. So a lot of times this is common for young couples who go out and buy a big life insurance policy and have young kids. Another common reason people do irrevocable trusts for people who are charitably inclined. There are certain charitable trusts that people use where they say, I'll give it to the trust, but I get a certain amount for the rest of my life. And then when I die, it goes to charity, is another common irrevocable trust that people do. Next slide. Then lastly, we get to a will on the next slide. If it's working, there you go. And then go on one more. And so a will is kind of the document of last resort. But even though we all think of it as being the most important document, has there been a reading of the will after someone has died? And commonly a will is really the most irrelevant document because you got to look to title, you got to look to designations. And then a lot of times the people who have more assets will have a trust. But if none of that applies, no trust, no designation, no title, joint ownership, then the will apply. And will is associated with probate, meaning I got to go down to the courthouse and file the will with the courthouse and get a lot of paper pushing, a lot of formalities, get someone appointed executor, and all that kind of good stuff. So there's a lot of formalities to having a will become effective on the transfer of assets. Normally, if someone does a revocable trust, then the will really doesn't address much, and probably it only addresses your personal stuff, the stuff that doesn't have a title, the stuff inside your house. And so commonly that's all the will really disposes of, especially if you do a revocable trust. And Arkansas allows you to always, you can do a little memorandum that you attach to your will that says, I want this thing to go to that person and this thing to go to that person. So you can always add a little on your own, type it up or write it out, sign it and date it, a memorandum to your will that addresses who gets it's only tangible personal property. So things you can pick up and put in your pocket, and that type of thing. You can always do a little memorandum that says who gets what. Next page. So the default, the next page. So if you have nothing, which occasionally I'll come across some people who don't have a will, or their designations fail, or they're not married and things aren't owned jointly, then the state of Arkansas says, here's the plan. So if you don't have any kind of planning document for disposition of assets on your death, then the state of Arkansas says your spouse will get your home and a third of your property, provided real estate in the home will only be for the surviving spouse's life. So there's a plan for the spouse to get the home for life, a third of your real estate for life, and then a third of your personal property. And then the rest would go to your descendants, which would probably be your kids, and so forth. This is kind of a surprise to some people who a spouse dies on the first death. The survivor just automatically thinks the survivor gets it all. In reality, the survivor only gets a third, and the kids will get 2/3. So this is kind of a rude surprise to some people. But again, that's why we should all plan to make sure we map out how things we want to go if we die first, if we're married, and then what happens on the second death. Next slide. And yeah, that kind of gets back to the reasons. You may be able through designations and joint ownership to not even need a trust or not even need a will. Nowadays, if you have a retirement account, life insurance, and an investment account in a home, you could probably own the home jointly with your spouse. And then on those other 3 retirement accounts, life insurance, and investment accounts, you can do a payable on death to your spouse or payable on death to your children. So there are times where you say, I really don't need a will or I don't need a trust because I can take care of it elsewhere. Well, you probably still need something, because either there could be a simultaneous death with your spouse so that there's the joint owner and you both die. And then also you probably want to have a will just to nominate who you want to be in charge in case there's anything left to wrap up following your death. So you want to nominate your executor or your trustee. If you have minor kids, your will can nominate who you want to be the guardian of your minor children. It's not controlling, but it's pretty good evidence to the court of who you want to be the guardian. And then if you want to change the 1/3, 2/3 split if you're married, it's important to have some kind of document that says either everything goes to my spouse or whatever division you want. But oftentimes people who have substantial estates want to put some restrictions on what their kids can do with it. And so you got to have a document, trust in particular, if you want to say, my kids can only take out a certain amount a year, or this trust has to last until they're 50, or whatever the scenario is. So you got to have some kind of trust if you want to put any kind of restrictions on anyone just receiving anything outright. Next slide. And then next slide, transfer taxes. There's always a concern about, will I owe an estate tax? And so if you go to the next slide, back up one more. The estate tax world, when I got started in the late 90s, it was at $600,000. So anyone that had over $600,000 paid an estate tax. And And I mean, that if you had any life insurance or any retirement accounts, you were basically in trouble back in the 90s. But slowly it crept up. It crept up a million, then 2 million. And then it went up to 5 million. You know, 2010 was this weird year where you could die and not owe any estate tax, which you know, was just an odd year, but it just shows you how crazy the estate tax world is. You know, by this chart, you can kind of see it's not one of these evenly flowing graphs. So 2010, no estate tax, then it moved up to 5 million. And then in 2018, it was doubled from 5 million and some change to 11 million and some change. And it's planned, if you go to the next slide, it currently stands at 11.58 million per person, and it's projected to go to 11.7 next year. So a married couple, you can double that. And so in Arkansas, generally, you know the 50 families that have to worry about estate tax when the numbers are this high. Yet, I guess you got to getting a little political here. There could be an enormous change on the horizon if the Democrats win the Senate and Biden is declared officially the president. There's a chance, according to Biden's proposal, that this would go down to 3.5 million. And so those people in that gap of let's say you're a married couple worth $10 million, you're safe. Obviously, you're safe now, but you may not be safe next year. And so that's something to keep track with is any change in that arena, especially for those that would be on that bubble, that bubble of being worth more than 7 million, as either 3.5 as a person or 7 million as a married couple. You may want to consider possibly doing something before the law changes. And so it's always a roller coaster. You know, every 2 or 3 years, there's a threat of it going down. But so far, it's never gone down. It's always gone up, but never gone down. But this may be the one time it changes, but we'll have to wait and see. Each year, for those who have large estates, we encourage people to make their $15,000 a year gift to as many family members and other people. So you can give $15,000 a year per person per donee. So a married couple can do $30,000 a year. And then there's unlimited educational and medical expenses. So getting grandparents to pay for college and braces and all that kind of stuff. For those who have big estates, we encourage those unlimited gifts along with the $15,000 per year. The problem with the estate tax is a punishing tax. If you pay it, it's 40%. I think the Biden plan pushes that up to 50. And then there's a thing called portability that no matter who dies first, if your spouse dies, you get to use your exemption plus whatever your spouse didn't. So a married couple can always double the exemption amounts. Next slide. There's some income tax issues on death. When you die, if you have appreciated assets, then what the income tax basis increases to the fair market value. So whoever receives your gift can sell that asset and not have any gain. And so it's better to inherit on death an appreciated asset as opposed to have a parent give a child an appreciated asset, because if the child sells that asset, they have a big gain. So a lot of times I have to talk people out of making a gift to their child if it involves an asset that's appreciated, because those are the assets you want to hold on till death, and then the child gets and they can sell and not have any gain. So it's important to look at not only if there's an estate tax issue, but then also there's this income tax issue of planning with appreciated assets. And if you're married, there's opportunities there that you can, on the first death, you can inherit everything from your deceased spouse, all these appreciated assets, and then you can turn around and sell them for no gain. But you gotta do there's a special type of planning. A joint trust is what you got to use, or some kind of powers of appointment. So there's planning opportunities if you have a lot of appreciated assets that you plan on selling. You can design your affairs to where the survivor can sell those without having any capital gains. Next slide. And then with charity, a lot of people will give charitable bequests on their death. You really, unless you're paying an estate tax, there's no tax advantage to giving money to charity. People will all say, I want to give $25,000 to my church when I die. Well, we've got to word that differently. We end up saying you have to word it to say I'm giving $25,000 of my estate's income to those church or whatever the charity is. So there's just a funny way. If you're wanting to leave something to charity, make sure it gets worded in a way to where your family can actually get income tax deduction. Otherwise, there's no tax benefit to leaving a gift to charity upon death unless you make sure it's paid out of income, and you have to go out of your way to say that. Or alternatively, sometimes you give it to your kids and then they understand that you want this to be given to charity and they get the deduction. So there's little tricks you got to play with charitable bequest. For those who are 70 and a half and have an IRA and give things to charity, visit with your broker or whoever manages your IRA, and you're allowed to make gifts directly out of your charity, out of your IRA to charity. And that's almost always a better way to do it than for you to take your required minimum distribution and then make the gifts. So there's a convenient way for you to send money directly out of your IRA to charity. And then last slide, I'm almost done. Just in conclusion, powers of attorney, you got to have those. Everybody should have a general power of attorney, healthcare power of attorney that says, here's who I want. I'm handpicking these people to make my decisions when I can't. And so you should all have those because odds are at some point we'll all become incapacitated. Living will is also important if you have a desire to not have any heroic efforts done to keep you alive. If you want to make any organ or tissue donations, you would want to so designate. And then you need to, at some point, just review your assets. Here's the assets. Here's how they're titled. Here are the ones that have some kind of beneficiary designation on it. And have that in a written format, because at some point someone's going to have to step into your shoes and figure out what you owned and where is it at and what everything is. So it's probably good to have a little inventory of assets, how they're titled, if there's any designation. And then more than likely you need at least a will at a minimum to say, here's what happens if I can't do these designations or things aren't owned jointly. For those who have a lot of assets or complicated assets that you can't do designations with, a revocable trust is recommended. And then lastly, if there's some planning reason, you should consider an irrevocable trust. Oh, sorry, that's it for me. I went over my time. I don't know if anyone's got questions. Feel free to email me or speak up or whatever the easiest way to do it.
You have a few questions in the chat box. One, it says, who draws up the power of attorney? A lawyer?
Yeah, typically it'll be a lawyer. But as I said, the state of Arkansas has, you can probably Google it, Arkansas statutory power of attorney. The state of Arkansas has a statutory form that you could probably download, or you can probably find one on the internet. But normally when people come to see me, they're in need of a will or a trust, and so as part of just the overall package of things, we would do a trust, a will, and the powers of attorney, all as part of just a package of the documents for someone doing estate planning.
Next question. Does an anatomical gift cover surgical hardware for recycling or whatever, like a hip or a VAD pump?
That's a good question. I don't know. Yeah, that's a good question. Never been asked that. And I don't know, you would think it could. I guess there's no harm in saying it. I guess it's a question of if someone would be willing to accept it. But yeah, I mean, I would say there's no harm in making that designation.
I have no more questions in the chat box unless someone else that's still on have any questions.
All right. Well, many thanks. Thanks for
Just
putting
one,
together.
if you have a revocable trust that was drawn up in a different state, is it still valid in Arkansas, or does it need to be reworked?
Yeah. Trust cross state lines, but yet you're subject to whatever state it was in, and so the trust will probably say this trust was created in Texas and it's governed by Texas law, and so it's still considered the original state. It's still considered a trust in that state. But yet you probably don't have to redo it unless there's something there's some disadvantage to being a first state trust as opposed to an Arkansas trust. But no, there's no imminent reason why you have to change that. Where with powers of attorney and wills, those are very state statutory controlled documents. And so with powers of attorney in particular, you may want to consider doing an Arkansas one, even though in all likelihood, the out-of-state one would be accepted. People just don't, people get used to the way Arkansas ones look. And if you come in with an out-of-state one, sometimes banks and healthcare people get nervous because it doesn't look like the normal document they see. But generally speaking, they should all apply, other than there could be some quirky things with the will and power of attorney that you probably need to get one done in Arkansas. Well, if there's nothing else, again, feel free to email me. I think my email's on either the last or the first slide. Yeah, the last slide, cwestbrook@fridayfarm.com. If anyone has any questions or comments, feel free to email me and we'll follow up with you. Otherwise, thank you for your time. And Mrs. Hurd, thanks for putting all this together for us.
Thank you for taking your time out to do this. Have a great day.
All right. Bye-bye.
Bye.